So I never understand how 5 past always becomes 10 past. I blame the clocks myself. Before you resume, my lady just has something she wants to raise as a result of her further researches over lunch.
Well, I was just looking at the provision in the 1971 Act which creates the Common Travel Area, Section 3, and does it actually permit an exclusion order to be made in respect of the person who's entitled by Section 3 to come and go? I mean, this isn't an issue that's being considered in the case, but if you could deal with this in your joint note, that would be really helpful. And if you don't agree about it, set out your different positions.
Certainly. Can I also just deal with something that we both discussed as well, but we thought we ought to, I think we both agreed, we should sort of, given some of the questions, we ought to draw the court's attention, because there was, I think, a question about sort of potential application for citizenship. One thing that happened early on in this case, not in the supplementary bundle, but there is correspondence which we'd be confident we can get hold of if need be, was that I think it may have been my lady suggested that there should potentially have been a stay to enable an application.
I think that is in the supplementary bundle.
Is it? Okay.
Yeah.
I couldn't remember. Sorry, I didn't go back and look in to see if that correspondence.
Yeah, no,
was,
it is.
And just to say that the applicant, for reasons that are consistent, obviously, with the point she's made, said she didn't want a stay, and that's why the litigation is proceeding.
Yes, no, thank you. We were aware of that because my lady had mentioned it to us. But where does that go?
I don't think anywhere, but it was just partly because there'd been questions
No,
about
fair
the
enough. No,
application
no, I'm
process.
not blaming you. I just want to make sure that I was missing some point.
I'm not making a positive point about it.
No.
And it just seemed to us that we potentially ought to mention it.
Right.
One other thing, just from sort of holdover from this morning that I was going to mention. My lord asked me the question, and I didn't finish it because of the alarm, the fire alarm, as to why in practice essentially would there be differences potentially between between exclusion rather than deprivation. And my lord identified 2 points for me. One was the
language.
The language. The second was the political reality potentially of the situation. And this is where I was getting onto proportionality. What I was saying was that although in both contexts there almost certainly is going to need to be a proportionality assessment, if you're depriving someone of their citizenship, the deprivation, of course, has to take into account the fact that you are taking, to use the language of Lord Mance, I think it is in FAM, a draconian step. And so the proportionality balance is not necessarily the same. And that explains why, although the language of deprivation is, of course, language that's, the language is conducive to the public good, which is language which is regularly used in immigration context, particularly deportation. There's a deportation ground conducive to the public good. No one has ever suggested that anyone who could be deported could also be deprived of their citizenship, because you're taking a more draconian step, effectively. So you've got to have a more powerful justification.
Right. Well, that doesn't help, because the fact that you have to have a more powerful step doesn't mean that if you've got the same set of facts, that wouldn't satisfy the more and the less powerful. It doesn't help at all.
Well, no, but my lord was asking about what the difference in principle between the 2 exercises were. And the point I make, the reason I make that point is that if you've got a decision, and in one
I think
sense
all you're saying is it doesn't follow from the one that you get the other.
Exactly.
Yeah,
exactly.
I see that. But it will, this last point, it will entirely depend on the facts. If the deprivation is in the circumstances that we're talking about, namely you apply for it on Monday, get it on Tuesday, and are deprived of it on Wednesday, and have never lived in this country, it's very different from the more standard situation where you're deprived of it having lived here all your life.
Yes.
On the basis that you're a dual national and we want to send you back to the other country where you could go.
Yes. What I'm saying, I think, is if you compare the situation as the Secretary of State believed it to be, because the Secretary of State wasn't aware of this issue when the decision was taken, as we've touched upon this morning, if you're taking a decision where you're excluding someone who, as far as you're aware, has never been a British citizen, hasn't been deprived of citizenship in a discriminatory manner, they are simply an Irish citizen, and you're excluding that person, that may require a different balancing exercise to the balancing exercise associated with depriving someone who is a dual national of their citizenship. That's the point I'm making, is it doesn't mean, I completely accept the fact that there won't be a group of people who are both potentially going to be excludable and also could be deprived of their citizenship, but that's not necessarily exactly the same group, is the point I'm making, because the proportionality exercise may be different. That's why, in one sense, it goes back to the point I was making this morning, which is you need to look at what would have happened, not just what could have happened.
Yep.
Can I then go on to the merits of my own friend's arguments, really? In our submission, the starting point, and really the end point in this case, is the judgment in Johnson, because in our submission it essentially determines the issues. And whether or not the Secretary of State likes the outcome in Johnson is what it is. And it's binding. Johnson, so the relevant passage starts at 228, and we would have the London authorities, it's tab 13. Sorry, although I have a hard copy of the bundle, mine hasn't been split, so I'm not quite sure where the split is.
It is tab 13, volume 1, yeah.
Thank you. Yeah.
Can I register a little moan about the copy of Johnson and the authorities? It's actually reported in the appeal cases as it's clear, it should be clear from the fact that it's 3 witnesses.
Yes.
Sorry, that's a very pedantic point.
It's nice that my lady makes it for once, because I'm the kind of person who is increasingly embarrassed at making these points. But they are slightly important. So I don't know who puts these bundles together. Can you make?
Yes.
It's often, I think, done by teams in chambers of clerks, and I think clerks do need a bit of training. I mean, they do a jolly good job generally, but things like if something's in 3 weeklies, you know it's actually in the appeal cases. They either have to be told to work that out for themselves, or more likely, counsel has to make quite sure they get the right copies.
Yeah.
And we don't have the benefit of your speech, Mr. Southey, which we would have if we had the appeal cases.
Yes,
I'm
quite.
afraid to say I haven't gone back to read it, but it would have been scintillating, I'm sure. But it's quite useful to know what the arguments were.
Yes.
Okay, well, we've made our point, but if we don't go on making it, it gets missed. Anyway, right. I'll tell you what, we'll punish you by asking you to send us a copy of the appeal cases,
Yes.
a soft copy after
Yes.
this, so we can.
I just in defence of Matrix, obviously we didn't prepare the bundle, and actually we do have lawyers who do it for us, so.
Okay.
I
think it was on our side.
Oh my goodness. Well, they were trying to stop us reading your speech then, Mr. Southey. It's worse than we thought.
I apologise for that. We will find the right versions and send them to the court.
Right. Yes, no, sorry, we've done that. Johnson, yes, substance.
Substance. Melania Friend started, I think, at paragraph 32, but actually one does, in part because of an issue that Melania Friend, the skeleton argument on behalf of the Secretary of State raises. An issue that is raised in that is the intensity of review, and 30 to 31 is where the Supreme Court clearly determines what the intensity of review should be in this context.
Very weighty reasons.
Very weighty reasons.
Yep.
And whatever has been said more generally in SC, nothing in our submission has been taken has called that into question. In fairness to Melania Friend, although I would say it's in this written skeleton argument, it's not something she particularly press. What then is key in our submission is that having looked at that, the Supreme Court quite clearly look at in our submission two issues that they address separately, and the reasoning in relation to them is different in our submission. And this was clearly something that.
Sorry, can we just pause there? You're talking about the distinction between the bits up to 36 and the bits after.
Yes.
I mean, I first thought, just as you, I think, are about to say, that I put it to Ms. McGuckie, that there's an important break there. But is there really? The only difference between the bits up to 35 is that there was it was about certification, so there was a very narrow test about clearly unfounded, not clearly unfounded, sorry, whatever the test was. So it was clearly unfounded. But really, the argument is a continuum. It's merely that because it was about certification, that she could have stopped there, but she decided to go on and give a declaration of incompatibility. But it's all the same points, isn't it?
No, Lord, I wouldn't.
Okay, well, fine.
The reason,
well, you know what
just to make there are a number of reasons why I would submit that's not the correct one. Firstly, if you go back to paragraph 2 of the judgment, paragraph 2, the first two sentences make it clear that what the Supreme Court thought they were dealing with and what they were clearly seeking to deal with was the specific issue of liability, or as they put it, right not to be deported, liability for deportation. They were separating, or they were identifying that as a particular issue that needed to be given consideration. One reason in my submission why that was the case is because if you then go to back to paragraph 32, the Supreme Court started paragraph 32 by commenting about how the case had been, to use Baroness Hale's language, bedeviled by arguments about precisely what has to be justified. And that's a reference to the fact that, if I remember rightly, the Court of Appeals judgment focused on effectively the point of birth, the fact that there was a differential treatment at birth. And that was why the Supreme Court was interested in and felt the need to clarify precisely what was in issue. Now, with that in mind, they then come to paragraph 34, and obviously we place particular weight on paragraph 34, but focus at that point on what they describe as current liability.
Yes, namely deportability.
Deportability.
Yeah.
Yeah. And deal with that separately, because that is the point, effectively, that we would submit was being made there, was that the answer to this argument, effectively, the discrimination was historic, was, in the mind of the Supreme Court, and we say correctly, was on what the current situation was, and the fact that you were, Mr. Johnson was facing treatment which he could not have been subjected to had he been a citizen at birth. And that language, and that's where in our submission, I'll come on to the two European court cases, where in our submission the approach of the Supreme Court does chime with the approach of the European Court of Human Rights, because it's focusing on what the present position is, essentially.
But is it just that, or is it the contrast with 32 and 33, the things that aren't going to be justified for them to reach a decision in this case. And one of the things that they say they aren't actually having to address is whether the continued denial of citizenship in 2012 is justifiable. It's about 4 lines down from the start of 32. So they say a number of things are not actually the things that have to be justified. And I'd have anticipated that your case would have been, if the Secretary of State is right, that is precisely what does have to be justified, because it's, the Secretary of State says, citizenship from which all else flows. And I thought you were going to say, but perhaps I misanticipated, that if you read 32, when you get to 34, it's obvious, I thought you were going to say, that the Baroness Hale thought you had to justify different bits, however you describe them, of the things, in inverted commas, to do with citizenship.
I, in one sense, was going to go on to say that, because that's that also links into what in my submission follows in paragraph 36, because paragraph 36 onwards is essentially where that separate issue, which is not before the court, is then addressed effectively.
Well, the issue is before the court in the sense that you must have asked for a declaration of incompatibility.
We did ask for a declaration of
incompatibility. So isn't the position that in the first part of this passage, Baroness Hale is dealing with the attack on the decision to make a deportation order?
Yeah.
And she says, if you go back to the reasoning, the Secretary of State was not obliged by the 2007 Act to make a deportation order in this case because exception 1 applied. Therefore, his appeal against the certificate is bound to succeed because his human rights argument against that decision was not clearly unfounded. She then goes on to deal with the position, what if he or someone in his position were to apply for citizenship, which is a separate issue.
Absolutely, my lady. But that's the point. In one sense, I'm making is that.
Well, that's what I thought you might be saying, but perhaps I'm wrong.
Sorry. Yeah. Sorry. What I was trying to do with sort of going to the structure of the judgment was to make the point essentially that up until paragraph 34 is dealing with what might be described as the primary issue, the issue that's identified at paragraph 2 of the judgment, which is, can you justify, or could the Secretary of State justify the deportation in this context? And that's what paragraph 32 focuses on. It's identifying what's in issue. Then you get to paragraph 36, and paragraph 36 sort of goes on to the sort of broader issue, which is the fact that Mr. Johnson, even if he couldn't be deported, was still not entitled to citizenship, and dealing with that as a separate issue, and that's and as my Lord Justice Lewis points out, it's clear that is dealt with as a separate issue, in part because when you start from paragraph 32, looking at what needed to be justified in the first part of the judgment. When I say first part, I mean paragraph 32 to 34. The Supreme Court expressly excludes the need to consider whether or not there was justification for denying citizenship. And another way of looking at another reason why that's clear is that when you get to then paragraph 36, which is looking at citizenship, the Supreme Court does then recognise that there are arguments being put forward that need to be grappled with about the justification for the application process. And so it deals with those and concludes that there is a justification for an application process, but there's not a justification for the good character requirement. But had the issues been linked, it's very difficult to see how, going back to paragraph 34, the Supreme Court would have said, well, there's no justification even suggested here for the difference in treatment.
But I think one of the points made, and I think this is the point Mr. Garney was making, is that the reasoning in 36 and following shows, or might show, why it is that Baroness Hale adopted the analysis she adopted in the first part of the judgment. And that's because he couldn't have applied for citizenship because of good character requirement. I think that's what her argument is.
But my point
so
is...
that's a premise of the analysis, even though it's not stated in the first few paragraphs of the passage.
But my point is that simply does not reflect both the structure of the judgment and what is said in the judgment about the way in which Baroness Hell is approaching matters. If Baroness Hale had been of the opinion, effectively, that the need to apply for citizenship, or rather the benefits of applying for citizenship, could justify the deportation action that was in issue. Para 32 in my submission would have had to read differently, in the sense that there would then have needed to be consideration of the denial of citizenship and whether that was justified. Para 34 would also have had to take account of the fact that the Secretary of State was putting forward effectively a justification as to why Mr. Johnson couldn't be a citizen, a character requirement, and the need to make an application. And so it would have had to grapple then with whether that justification was an adequate justification.
But it may be that the argument wasn't put forward. Because, I mean, I certainly don't know because I haven't seen what was and wasn't argued. But one of the reasons there may not be, that may not feature in that stage of the analysis is it wasn't being suggested that was a route out on the facts of this case.
Well, we can certainly provide the appeal cases. I can provide the written cases from both sides. I'm pretty sure that I will have those somewhere.
Don't you keep them in all your House of Lords and Supreme Court cases? Don't you keep them in a neat row or somewhere in your?
No, there's a box of memory sticks, I think, is what it is.
Oh, I see. What a shame. Okay, yes, sorry.
But do you also say that when you look at 36, it's not tied to deportation? And the example that Baroness Hale gives is of other consequences of citizenship or lack of citizenship. And she gives the example of people who can't vote because their parents were not married. So it looks, you might want to say, as if she's moved away now from an incidence of citizenship or something separate called deportation. And when she gets on to 36, she's trying her best to show how the next set of paragraphs are tied with broader things rather than being a premise on the thing she's already said. But it's up to you really how you put your case.
Well, no, my lord, I agree with that. And I was going to put, and that's also, I think that's shown most clearly by paragraph 36, and where she starts with the sentence allowing this appeal in consequence of the particular provisions relating to, is the consequence rather of the particular provisions allowing relating to deportation. So she's effectively saying there, paraphrasing, but my submission fairly, I don't really need to, on the facts of this appeal, need to go any further, but there are going to be other people who want other benefits, effectively, and that's where I need to go further.
But the claimant might want to go further because he might himself want to apply for citizenship.
Well, he might, but his particular concern at that stage
was to, obviously, his immediate and pressing concern was not to be deported.
Absolutely. And that, I mean, again, if I remember rightly, I think it's clear from the judgment, that arose because the decision actually challenged would have been the decision to certify. Yes, it's page 220 rather than the bundle. Under the list of cases, the claimant Eric Johnson claimed judicial review of inter alia the decision of the Secretary of State on the 23rd of November to deport him as a foreign criminal and to certify his claim that deportation would breach his human rights as clearly unfounded.
Yeah, so that's implicitly a decision that exception 1 in section 30, whatever it was, didn't apply to his case.
Exactly, exactly. And so that's why, but in one sense, that again it explains why at paragraph 36, the start of paragraph 36 in my submission, what Baroness Hale is saying is, well, paraphrasing, but hopefully not unfairly, in one sense, I could stop here, but I'm not going to stop here because there are the potential issues that arise as a result of this.
Which were raised by the claimant.
Which were raised by the claimant.
Declaration.
Yes, certainly not obiter, it's just different.
Well, I mean, in one sense, obviously the declaration of incompatibility needed to be raised, because if we were wrong in our analysis that you could separate out these issues, I mean, if the Secretary of State were correct and were in saying effectively you can't separate out the issues, then in the Johnson case, what the court would have, in my submission, effectively had to do is to say, well, this is there is a way out of this, which is you can make an application. It's not open to Mr. Johnson. That is that's an item of primary legislation. Because it's an item of a consequence of primary legislation, all we can do is make the declaration of incompatibility, because Mr. Johnson, the answer to Mr. Johnson's complaint about deportation would have been to say, well, citizenship is your answer, but you can't get citizenship because of primary legislation. But that's, in one sense, why it was important from Baroness Hale's point of view to deal with the issues separately, because you needed to consider whether or not there was an answer to the deportation case separately from...
Maybe so. That's not how she explains why she's dealing with it separately.
She explained... Well, in one sense, she doesn't explain... One could say she doesn't explain why she separates the issues out, but she clearly needs to separate the issues out, and she clearly does separate the issues out. And part of the reason she needs to do it is the point I made a moment ago, which is that she needed to identify precisely what was an issue, because of the issue of timing, effectively, and whether this case was all about something that happened many years ago. And part of the reason why she needed to identify what was an issue because it would have potential implications for relief. And I mean, ultimately, in relation to the citizenship point, she was quite clear she could only make a declaration of incompatibility.
Another interesting question is, what would have happened if Baroness Hale got tired after paragraph 35 and went no further?
Yeah.
What would have been the position? The position would have been, the appeal would have been allowed, the certificate would have been quashed, and there's an obiter dicta saying that the appeal, when it was finally heard, would no doubt succeed for the reasons already given.
Yes.
If she'd then had a second wind and got on to 36, she might have said all those things, but you would say, I imagine, that if you stop at 35 under the helpful heading conclusion, that gives the clue.
Well, I think it's in the guys.
It's all of those things. It's 32 and 34, it's 35,
yeah.
It's the example in 36. You say it's everything taken fairly.
Yeah. And the logic of her position in our submission as well, it has to be in some senses that these are separate issues. Because if the answer simply was to what sort of precedes paragraph 36, paragraph 32 to 35, if that was simply to say the answer to that was simply enact a system for registration, the implication of that would have been that, for example, despite what is said in paragraph 32 to 35, the Secretary of State could potentially have deported someone who already could apply for registration, but hadn't applied for registration for whatever reason. Because, of course, in Mr. Johnson's case, there was clearly a reason why he couldn't apply for registration, which was found in the statute. But there would have been others who, for whatever reason, had good reasons for not applying for registration or hadn't got round to it or whatever. And yet, if this was simply the product of the fact that Mr. Johnson couldn't register, that group of people, even though they were also being disadvantaged, would potentially have been deportable. And that, in our submission, doesn't make any sense. That's not what Baroness Hale is saying. She's quite clearly saying you can't deport people whose parents who are only denied that protection because of the fact their parents weren't married. Remember, the Secretary of State accepts there are a number of people who may well have good reasons for not applying for citizenship. The logic of the Secretary of State's argument would appear to be that even though they may have good reason for not applying for citizenship in light of the way their life has developed, they are then deportable, even though they wouldn't have been deportable had their parents been married. So,
well, yes. What does one make of the phrase at the top of page 230 of the bundle, and no justification has been suggested for it?
Well, what that must mean in my submission, it goes back to the point that I made a moment ago about the distinction essentially between, that in my submission clearly draws between deportation and citizenship, in the sense that the justification that was essentially being put forward, the justification that was being put forward essentially, and you can see that in paragraph 35 and 37 and 38. The justification that essentially was being put forward is that there is good reason for having an application process, essentially. Now,
well, hang on.
But isn't what worries me about this? I obviously see how you put it, but the phrase "no justification has been suggested for it" does suggest that a justification might be possible. But namely that you can always apply for registration. But that hasn't been suggested in his case because he can't apply for registration because of the good character requirement.
But look, the Secretary of State's position, obviously in relation to the citizenship, was not that there is no justification for him being unable to apply, because otherwise the Secretary of State would have had to concede the declaration of incompatibility. The Secretary of State sought to defend the good character requirement.
Yeah,
and so had there been that linkage, what Baroness Hale would have been saying there is a justification has been put forward, but it's a bad justification.
Yeah.
Does the last sentence of 39 help at all, or does it not help?
Well, again, it's my lord, I missed that, I think, but it's consistent with the point I'm making, which is that para 36 to 39 are effectively, in one sense, an add-on.
Mm-hmm. I was thinking, what if she stopped at 35? But in fact, when she got to the end of 39 and finally put her pen down, she said, what I've just said, I'm going to do, but it isn't necessary to dispose of this case. So.
Yeah. Well, exactly, and paragraph 39 is, my submission, the last sentence of paragraph 39 again is consistent with that.
You rely on it then, yeah.
Can I just also go back to my Lord Justice Underhill's, my Lord Vice President, rather, question about the line "no justification has been suggested for it." It is important to bear in mind something that we sort of highlighted in our note in response to my lady's questions, my Lady Justice Laing's questions, which is that, of course, I don't think this is in dispute, listening to Ms. McGuire's submissions this morning, which is that, of course, what has to be justified in this context is not the treatment, it is the difference in treatment. Mm-hmm. And so if you focus on, in the Johnson context, the different liability, effectively, for the difference in liability for deportation, the existence of the liability in one case and the absence of one, then one sees why it's being said there was no justification, because what wasn't being said is by the Secretary of State is essentially there is a good reason why I should be more able to deport people whose parents didn't have to be married. The Secretary of State's case essentially was we have good reasons for not permitting people with bad character to apply for citizenship, but that was obviously not a justification for differential powers in relation to deportation on the basis of parental status. And that's why that, in my submission, that line was there. Well, I think probably, I'm not sure there's much more I can say about Johnson.
No.
I think that probably covers everything that can sensibly be said. Can I just deal with sort of some of the other points that have just been made about the objections, essentially to the approach of SIAC? Laing trend on a number of occasions made reference to citizenship being a single package of rights and duties. An argument one might think that was potentially open to the Secretary of State or implicit in what the Secretary of State was saying in Johnson, where character was being raised. But in any event, the point about that is one has to be very careful in my submission to analyse, in one sense, what the duties are of the British citizen in this case. The British citizen in this context isn't required to do anything to assert their nationality. They're not required, for example, to take an oath, the comparative group, because they obtain citizenship.
You mean the person born a British citizen?
Sorry?
You mean when you say a British citizen, you mean a person born a British citizen?
A person born a British citizen. Yeah. Yes, they're not required. They're not required to do any of these, take any of these steps. All they're required. I mean, and particularly in the context of Northern Ireland, this is where we made reference to the Good Friday Agreement. The reality of the situation is that a British, someone who's born British in the context of Ireland is entitled to self-identify as simply being Irish, but of course they still enjoy the protections of being British in legislation, so that the Secretary of State can't deport them, can't exclude them.
Yeah, but in that sense, they are relying on their British citizenship.
Well, they don't positively need to do anything to acknowledge that citizenship. In one sense, and this is why I was using the language I used a moment ago, I mean, the starting point is that the Secretary of State has to identify what powers she is using when she takes action against the individual. She has to identify them correctly. And when she uses those powers, if she's aware that someone is a British citizen, even if the individual positively decides they don't want to identify as British, she can't exercise those powers in that circumstance.
Yes, but when push comes to shove, they will have to. Suppose she tries to deport someone who has self-identified as Irish, only carries an Irish passport, but it turns out that they are in fact British from birth. Their defence in the claim in the answer to deportation is, "I am British." They will have to assert they're British.
They'll have to assert they're British, but they'll have to evidence that their entitlement to.
Well, that is in law. In a pleading, they would have to say, "I am British," so you can't do this.
But there is still, I mean, in one sense, the Martin McGuinness case is we would submit potentially supports us in the sense that if you think about the McGuinness case, for example, the individual is Mr. McGuinness hadn't revoked his citizenship, but at the same time had an objection to positively asserting that citizenship, and that demonstrates in one sense how there is a particular sensitivity about asserting citizenship and.
Yeah, I mean. I speak for all of us, we quite understand the sensitivities in Northern Ireland and a large part of the community in the north, though in fact of course it happens not in the north, but will not want to, in a broad sense, assert their Britishness.
Yes.
Got that entirely, respect that. And as you say, it's reinforced by the Good Friday Agreement. But in certain legal contexts, if they want to avail themselves of protections or rights that occur to them as being British, they will have to assert that they are British.
Well,
you can't. You can't have one without the other.
Well, except in one sense, the starting point is that the Secretary of State has to act lawfully, and if the Secretary of State has sufficient information, that means the process won't start. So the Secretary of State may know that someone was, for example, was born in Northern Ireland. In this case, it's slightly more complicated because the Secretary of State wouldn't necessarily have known about the route to citizenship, but the Secretary of State might well know in other cases.
Yes, but at the moment, I'm not really following the submission. Is the submission that if a person asserts that they're entitled to British citizenship, I mean, this is all about the preliminary issue again, they should be treated as being a British citizen even though they aren't? Because in law, you're not a British citizen unless either you acquire citizenship at birth or you acquire it by registration.
It was a slightly different. Sorry.
It's probably me.
No. It's slightly because to put it back in context, the reason I started from this point is, or the reason I started on this point was to respond to Malone and Friends submissions that citizenship is a bundle of rights and duties, and all I was suggesting fundamentally, and this is where I was talking about identification and the fact you don't have to identify as British, is that the comparative, the person who was born British, in terms of what their duties are, the only duty effectively they are subject to, if they are not going to be subject to the Secretary of State's powers in the context of citizenship to prevent someone coming into the United Kingdom, which is to deprive and then exclude. The only obligation they have is simply not to behave in a way that would justify that deprivation. So they're not subject to, if you like, the duties that Malone and Friends says are reasonable duties to impose on this appellant to apply for citizenship, to positively assert their citizenship.
Well, the reason why people from that committee don't want to do it is they don't want to swear allegiance to the British Crown, and they don't want to swear allegiance and loyalty to the British state. Yeah. And if you look at the history of the Republic of Ireland, you understand why people of a particular committee would take that. But what is said against you is, if conversely you want the protection of the British state, then that comes at a price. If you want the state, you must accept allegiance to the state. If you don't want the state, you don't have to accept allegiance. That's all that's said, I think. And I mean, I understand, as you'll tell from my accent, I understand the point about loyalty to the British state and to the British Crown.
But the point I'm making is that when you look at that, there's a difference into the person who is born British. All they have to do in terms of allegiance to the Crown is effectively avoid getting in a position where they're being deprived of their
citizenship. He will get the benefit of the British Crown, his officers and his border officials, and he will get the protection of the British state without having to say so ostensibly.
Exactly.
But Miss McGahy's point is that you might not have to say it through gritted teeth, but you have to accept it as a consequence or as the flip side of the coin.
Well, in one sense, you go back to Johnson in relation to that, because
Johnson, of course, the particular point about Irishness and self-identification Irishness didn't arise. But Johnson is clear that in principle, a process of registration, and I think we may take it that the Supreme Court was aware that registration would require the taking of an oath.
Yes.
Is a reasonable part of claiming the rights.
If you want the full package, and that's the distinction. I'm talking here.
Well, doesn't it rather stick in the throat to say that you can have the parts of the package you like and not the parts you don't like?
Well, No, because it's not.
There's a particular problem I understand about the reasoning in Johnson, but we've got past that.
But the reason it doesn't, in one sense, is because it comes down to the fact that there is, in principle, a difference between the state taking positive action against you, which is what it's doing if it's seeking to deport you, and you saying, I want to enjoy the full package of rights.
Well, there's a distinction, but is it a relevant distinction?
Yes, because the state. Yes, because deportation effectively is, to use deportation as an example, or exclusion, is about denying you. It is about the state positively interfering with the way in which you have organised your life, effectively.
But in a sense, the state always does that, whenever it makes laws.
But it doesn't, in the sense.
You then have to comply with.
If you've organised your life in a way that, for example, takes account of that, I'm not quite sure how you would take account of it, but if you've organised your life living where you live, taking account of the fact that you may not be entitled to vote, taking account of what the limitations on your civic rights are within the United Kingdom because you're not a citizen, seeking then to positively benefit from those civic rights is, in our submission, in principle different to the state stepping in to effectively interfere with the way you have organised your right already.
Well, she's trying to assert a right, a positive right, to travel in the United Kingdom without let or hindrance, because I'm a British citizen. Every time she goes to Belfast to see her cousin, without having to show a passport or to get through the border, well, that's a bad example, of course, there's the special particularities about Ireland, but it simply going to, if we take this away from the Irish context, which I think we've got to do, because we're just considering a point of principle, someone who doesn't want to be excluded from a country is in fact asserting a positive right to go there and be there and not to be stopped from it. Well, that's I don't see that as a negative right or an immunity from exclusion. I think the boot's on the other foot.
Well, except this is where it may be difficult to exclude the cross-border element of this case.
Well, I think we've got to a different stage. It may come back in at a particular stage of the argument about the swearing of the oath, but or the taking of the pledge. But in the broader sense, even if the registration simply involved paying a fee and putting your name on a, you'd still have the same problem.
Well, no, except the reason why I was saying I'm not sure you can completely exclude the cross-border element is that if you have organised your life so that you live close to the border and part of your private life is in one side of the border, part of the private life is the other side of the border. I suppose in principle this could happen in Kent, but it's probably less likely given the physical physical barriers. But if you organise your life in that way, and the Secretary of that state then says, actually, part of your life, the part of your life that is on our side of the border, is no longer open to you, that is an interference with the life you're already enjoying.
Yeah, I think we're not going to get anywhere on that. But you could say that you are asserting a positive right to have a completely free and untrammeled life on the UK side of the border by virtue of being a UK citizen, which you wouldn't have if you were from any other country.
At the risk of going around in circles, but can I try and put this in a slightly different way, why there's a distinction? One way, potentially, of looking at this, which would be consistent we would submit with Johnson is to recognise that whenever an individual is denied a right in one form or another, whether it be the right to vote or the right to cross border, assuming it's a right that attracts the protection of proportionality, the state then has to justify it. One way of looking at Johnson, and we would submit makes sense, it would be to say that because deportation is and because exclusion are maybe coming back round to the point I was about to make, which Malone wanted me to move on from, but because of the nature of the impact they have on you, they can't be justified on the basis of your parents' status, marital status at the point of birth, and requiring an application for citizenship is in particular not an adequate justification, because ultimately, to enjoy that right, you don't have to be. There's no good social reason why you should be a citizen. If you look at the right to vote in contrast, the right to vote might be said to be something which is about the way in which society is organised. If you're going to exercise that right to vote, you should potentially have then committed to society in a different way. And that might be a reason for distinguishing. I'm not sure if I'm expressing that.
I wonder if there's a different way of analysing it. I know my Lord would prefer to have a one-size-fits-all approach.
Yeah.
But the problem for Mr. Johnson was he had a right to remain in the United Kingdom. He'd been granted indefinite leave to remain in 1992. And that state of legal affairs was being altered because he was being deported. Now, unusually in the case of Irish nationals, they too have an unfettered right to enter the United Kingdom because they are not subject to immigration control under the 1971 Act. So there you have two groups of people, those who have indefinite leave to remain in the United Kingdom, those who have an unfettered right to enter the United Kingdom, but who are not nationals. And if a power is being exercised which interferes with that right, it doesn't have to be analysed on your submission through the prism of citizenship in all respects, as Ms. McGahey says. The mere exercise of a power which brings about an alteration in a legal state of affairs which allows the person living in or being allowed to enter the United Kingdom will be unlawful if it involves a contravention of a convention right. And the question then is, does this case involve a contravention of a convention right? And I begin to wonder whether citizenship is relevant at all.
Well, my Lord, can
on that analysis, if you follow me.
My Lord, absolutely, my Lord.
One thing that worries me about all this is not a way the case has been argued
at all.
Below, or indeed here almost until this afternoon.
Well,
the Irish dimension has been relevant only because of the objection to taking the oath and the pledge. Otherwise, the position would be just the same as if they were a Jamaican living in Dundalk.
Well, can I tell? Well, firstly, my Lord, what my Lord put to me, I think, was what I was trying to put probably slightly much more inelegantly to my Lord. So I agree with that. In terms of the way the issue was put, the issue certainly was put that there is effectively the and this is what SIAC is dealing with. I think it's paragraph 47 from memory.
Well, the problem is, it looks as if you said she's got to be treated as if she's British, and the answer is no. She's got to be treated as if she's Irish, clutching a copy of the Immigration Act 1971. And nobody seems to have mentioned that. And I know I'm like a cracked record, but I keep coming back to that. What rights has she got? Have they been taken away? Were they taken away lawfully? It's just a simple series of steps.
Well,
and that wasn't how it was put, though.
The reference in my paragraph 47 I was referring to because it's the reference to immunities, and links back to paragraph 43, which is the reference to enforcement action.
Are we in the judgment now?
Yes, sorry, yes. Which is page 85. And that essentially a reference, effectively, to the fact that what was being said, and this is also reflected in grounds of appeal and references in particular to how Article 8 was engaged, is that what the Secretary of State is doing by excluding someone, and by excluding in particular Ms. Smith, is preventing her from continuing to enjoy a right she would otherwise enjoy.
So which paragraph of science judgment is
Sorry, 46. I think I said 47. I meant 46.
Yes, I thought you said 46. 47. Sorry, so
yes.
46.
46 and 43, and it's the second sentence of 46 where it's talking about immunities. That language may not be perfect language given the points that were made this morning, but the point is still being made, which is consistent with what I'm making at the point I'm making now, but it was the point that was being made below, which is there's a distinction between the state effectively taking action that denies you something you've already enjoyed, and you seeking to positively assert, for example, the right to vote, which you don't enjoy.
I don't want to be difficult, but
yeah.
I'm just looking at page 99, and I thought to myself, we're arguing now about what the case is all about. Let's look at the grounds of appeal. We've looked at the decision, and now let's look at why you say the decision was wrong. And you say the decision is wrong at paragraph 1 on 99 because she is a dual British and Irish citizen, well, she isn't. Or in the alternative, she's entitled to be treated as one, but she's not. And since that premise is wrong, the next bit of the sentence is irrelevant. Then you go on to say it's not sufficiently precise and it's disproportionate. And then you go on to say no factual basis for the denial of free movement of rights under EU law. So those are the three grounds. I don't actually see anything there that says this is an Irish person who's entitled to enter the United Kingdom without being subject to immigration control. And the exercise of the power is unlawful because that power wouldn't have been exercised in her case if her parents had been married. That's the problem that I've got with the grounds. And then you get to the judgment, and at paragraph 5, it's said to be a preliminary issue which is recast to say whether the decision challenged is unlawful because she's entitled to be treated as a British citizen. Well, the answer to that is no, it's not unlawful for that reason. It might or might not be unlawful for other reasons.
Well, my Lord, in fairness to me and my drafting and my learned junior's drafting, if one goes to page 101, paragraph 4, this may be the critical point which SIAC doesn't quote.
Well, this is the amended ground. There's no other amended ground. We're not focused on it.
Sorry, there are amended grounds. Yeah. And this is what SIAC was.
And it's ground 1 is a dual British national, and Irish is not, or in the alternative, but the entitled to be treated by reason of Article 14.
But if you go to paragraph 4, which is all part of ground 1, paragraph 4 says birth outside wedlock is a status for purposes of Article 14 and falls within the class of suspect grounds which rating. In this case, what requires to be justified is the current liability of the applicant to be excluded from the United Kingdom when she would not be so liable had her parents been
but that must mean because she would have been a British national.
Yes, but it reflects that in particular is intended to reflect, as far as I can remember. Sometimes very difficult to remember what you intended to draft.
Well, it doesn't matter what it's meant intended to do; it matters what it does.
But it does reflect the approach of Johnson, which is to say, by not in that sentence focusing on citizenship, but by saying there is current liability. The current liability, I assume, was taken from Johnson. That is exactly the language of Johnson. It referred to current liability.
Again, I don't want to be critical of anyone, but when you go back to paragraph 3 and 5 of the judgment at page 76, it appears that the Commission took the first sentence of paragraph 1 of ground 1 and then recast it in paragraph 5. And I just wonder whether the right questions have been even looked at yet, and whether we're not to say, let's start again and get it right this time, or at least get the right exam paper.
Well, I would say, perhaps not surprisingly, that paragraph 4 is expressed in terms of current liability to be excluded.
But where is that dealt with?
Well, that's essentially what SIAC is doing. That's why I took you to paragraph 46 And there's no, and Secretary of State's appeal grounds don't complain about that. If you look at paragraph 40, go back to SIAC.
Yeah.
The SIAC judgment. Paragraph 43 first, because logically it should be read first before 46, talks about well, it accepts a submission of mine that's recorded as being that what was an issue in at the start of the judgment in Johnson, or the start of the relevant passages in Johnson, was the question of enforcement action, and focuses on the language again of current liabilities. That's the language that was used in the grounds. Focuses on whether or not that liability would exist if the parents had been married, and says that's what can't be justified. And then with paragraph 46 goes on to the point about immunities. So in my submission, when you read in particular paragraph 4 of the amended grounds, which I've drawn attention to, which specifically uses the language of current liability for exclusion, and you then look at paragraph 43, whatever else may be said about other passages of both the grounds and the and SIAC's determination, it is clear that before SIAC was the issue of current liability for deportation revocation. And what SIAC expressly addresses at the heart of its judgment, paragraph 43, is that issue of current liability.
Yeah, I may have misunderstood what the Lord was saying. Simply wasn't part of the grounds. I thought it was limited more to a point about, he will say, about her rights as not as a British national, but as an Irish national, because of the common travel area, which is a statutory right.
Absolutely. Common travel area, I accept, wasn't raised below, although, and that, I mean, what was being obviously raised, which in one sense is a reflection of the common travel area, is the particular significance essentially of cross-border.
Yes, but that was being raised for a very particular reason.
Yeah.
It wasn't being raised on the basis that what's happened here is a discriminatory interference with a right which had nothing to do with citizenship. Well, I suppose it wasn't.
Yes, but I mean, in one sense, the discrimination wasn't in the discrimination in this case, because this is the power that was actually exercised that couldn't have been exercised if the parents had been married. That was the revocation. So that's why, in one sense,
Revocation.
Not revocation. Sorry,
Exclusion.
The exclusion under Regulation 23(5).
Exclusion. Yes. So that's why, in one sense, the focus was on that. The common travel area, accepted potentially of importance, but it's of importance in one sense. Its greatest importance is because, in one sense, it demonstrates how there is a particular importance of being able to cross the border if you're.
Yeah, well, I see that. Well, okay. Well, this aspect of the case, which has only emerged in the course of the hearing, we'll have to give some thought to. What we've against the background of it being a completely new point, not one, to be fair, raised by you, but we probably said as much about it as we can at the moment.
Yes, I mean, all I would say is our point is, in one sense, our point now, having heard the point, is in one sense we don't need to rely on that point, which may or may not have been open to us, because on our analysis of Johnson,
Sorry, that point being which point?
if you like, the need to potentially give weight to the common travel area as being a factor that demonstrates the importance of the rights potentially in issue.
Well, I mean, for all I know, the common travel area may be the short answer to this whole case.
Well,
it might make the exclusion order unlawful ab initio, in which case all the rest of this is
Yes. I mean, I sort of suspect it's not on the basis that you can...
No, it may well
somebody
be.
would
I mean,
somebody, it's already here. Somebody would have spotted it if it was.
Yes, yes.
But
we need to double check that. But
anyway, there we are.
I'm still puzzled. I mean, is this judgment of SIAC a ruling on a preliminary question so that other things will now have to be determined by SIAC? Or is it, despite the 5 paragraphs of introduction, a ruling on all the grounds of appeal?
It seems to be a ruling on all grounds of appeal because it's right
It
at
seems
the
to
end.
shift from one
Paragraph 52 says.
Yeah, I know, it depends which bit you read.
but it's what it's doing. SIAC, to put it in context, this is certainly how I understood what SIAC was seeking to do. SIAC sometimes, partly because it's advantageous to avoid closed material if it can, will deal with matters which are sufficiently sort of discrete that they don't involve closed material and that are potentially sufficient to cause the appeal to be allowed without then dealing with other matters that may require consideration. So, for example, it will deal with citizenship, as my Lord probably remembers. It will deal with citizenship as a statelessness as a preliminary issue. So, what it sought to do here is it sought to resolve the Article 14 ground, and because it's found the Article 14 ground in favour of the appellant as she then was, it's determining it doesn't need to go on and deal with the other grounds.
Because it's resolved the preliminary question in your favour as defined in paragraph 5, it therefore could immediately go to allowing the appeal because nothing else arose. So what happens if it's A, the wrong preliminary question, and B, the wrong answer? Does it have to go back and start again?
Yes.
Oh, right.
If you were to conclude that in fact it had answered the right question but had answered it wrongly, and that this ground of appeal should have been rejected, it would have to go back to SIAC because there would be other unresolved issues still to resolve.
Would that just show me which those were?
Sorry, could you just say that again? I just want to be sure what it is that you are or aren't accepting.
Yes, sorry.
So my Lord's question is, if the wrong question is asked and the wrong answer was given, does it have to go back? And you said yes, and then you added a qualification.
No, sorry. I think I said.
I've written down if it's the wrong preliminary question or the right question but the wrong answer, it would have to go back to SIAC.
I think I was intending to just say if it's the right question and the wrong answer.
It goes back.
It goes back, and the reason for that being
the other grounds
would still have to be. If it was
sorry, I'm behind, my Lord and my Lady.
Sorry.
Which are the other grounds that would then have to be determined?
They are. There's an Article 8 ground and an EU law ground.
Yes, I see. And where do I see those?
They are in the revised grounds of appeal, which are 101 and 102.
Right, sorry. So I'm still trying to get a note of exactly what you are and aren't accepting. So if it's the right question and the wrong answer, it would have to go back for the other grounds to be dealt with. Is that it?
If it's the wrong question.
If it's the wrong question, that might depend on what the question is, which is one of the reasons I hesitated, because clearly the court...
If they should have asked a different question from the one they asked, doesn't it have to go back so they asked a different question, whatever it is?
Well, except, and this is the reason why I'm slightly hesitant about it. I mean, ultimately, the... SIAC clearly had considerable argument, whatever the question, whether it got the right question or the wrong question, had considerable argument about the application of Johnson. You also have had considerable argument about the application of Johnson. If I am right in my basic point, which is clearly one that SIAC engaged with, which is following Johnson, enforcement action in the form of an exclusion order is not justified in this case, then in my submission in those circumstances, there would be no point effectively remitting, because the answer goes back to the point the Lord made about not focusing on what SIAC had decided in one sense, because the answer would be clear. This would be...
yeah, it depends if we can answer any point of law that's been properly before us.
Yes.
But I think that means you don't read paragraph 5 on its face as saying what it says in SIAC. You've got to read all the other things, which goes back to immunities and so on, because paragraphs 3 and 5 are based on the first sentence of ground 1 of the amended grounds of appeal, And what you're really saying is, although it refers there to as if they were British, in reality, when you read the rest of the judgment and the rest of Ground 1, although they said they were dealing with the first sentence, and although they recast it, they were actually also dealing with what you say is the fundamental issue of immunity, salami slicing, and so on.
Exactly.
Right. Where do we go now?
Can I just look through? I may well have covered everything that I need to cover.
You haven't said anything about Andreev and
yes,
and,
sorry.
Diaz.
Andreev. Yes.
Yeah.
A couple of things actually I need to address. Andreev. Obviously, we've said in our note that we do rely on them, and
maybe
are grateful to the court for identifying them. The key point that we make is that, and it links back to the point that we have focused in on in relation to Johnson. It links back to the reference to current liability. Fundamentally, in our submission, what Andreev and Munoz Diaz demonstrate is that when looking at discrimination, one needs to focus essentially on to use the language of the judgment, the present situation exactly as it stands. Now that's, in my submission, precisely what Baroness Hale did at paragraph 34. And precisely what we're seeking to do by focusing on this issue of liability for exclusion. Now, my learned friend's argument in relation to that is to say, well, there was a particular problem in both of those cases because the change, essentially, that the government was identifying, or the action that the government was identifying as a potential way of curing the problem that the applicants were raising, essentially was an action that would have eliminated the difference. But in my submission, there are two answers to that. Firstly, as I've already indicated, the language is clear. The reasoning of the court is primarily one needs to focus on the present situation. But secondly, the change of status here that the Secretary of State essentially argues should be change of status that's required in this case, according to the Secretary of State, is to naturalise, or is to become a British citizen. I accept that's not a change of status that changes the marital status of your parents, and to that extent there is a difference. But it still, in one sense, undermines Article 14, because what it's requiring the individual to do is accept, effectively, a difference in treatment, albeit a difference in treatment which is then different, in the sense that the individual is having to take steps they wouldn't otherwise be required to take. The individual has to go through this application process. And so, Article 14 is essentially undermined because the individual, what the individual is being told is to cure the difference in treatment that you're complaining about, you have to accept a different difference in treatment. The other question, I think, looking through my notes that I picked up that I probably need to expressly address is an argument that I think my lady also made reference to, which is whether or not there's a difference between exclusion and deportation. And in our submission, there isn't a difference, or not a significant difference, for a couple of reasons, really. Firstly, I mean, ultimately, deportation deportation and exclusion are both essentially intended to ensure that an individual is no longer present and no longer able to enter the United Kingdom.
Well, but there's a difference, isn't there? Because the premise of exclusion is that you aren't present, and the premise of deportation is that you are.
Yes, but that there is that difference, but that doesn't necessarily, and that may not be a difference of very much substance. If the individual has, for example, gone on holiday, you would exclude, the Secretary of State would exclude them rather than deport them.
Yeah.
I mean, fundamentally, they are both intended to ensure that the individual is no longer present, if they were physically present, and no longer able to enter the United Kingdom. And it may be that on particular, for some people, obviously, exclusion or deportation has graver consequences because in some circumstances, obviously, the person will have lived all their life in the United Kingdom, or a large part of their life in the United Kingdom. But ultimately, the way Baroness Hale approaches it in Johnson is not to say, well, this might have been sort of justifiable if Mr. Johnson was a recent arrival in the United Kingdom, but he's not. He's someone who's lived all his life, and that's because the question is the difference in treatment. It's not the impact on the individual that has to be justified. It's the difference in that treatment, and the individual. And I come back to what's the difference in treatment? It's essentially the same. It's that the individual who could not be removed from the United Kingdom, subject to the one exception, which is if they're deprived of citizenship, that individual, no matter what their ties with the United Kingdom, whether they're strong, whether they're weak, whether there's someone who's born British but has never been to Britain in their life, that individual retains their citizenship unless they're deprived, and so can't be prevented from entering, can't be removed from the United Kingdom. The other individual, no matter what their ties are, whether they're strong or weak, is potentially subject to enforcement.
Can you just remind me, when you're deported, I mean, does the Act say, I thought it said you can be removed, deported, that is removed physically from the United Kingdom. I also thought it said, but I might be misremembering this, that you're not allowed to come back within a certain period of time, and if you do, it's a criminal offence. So it's getting you out and not letting you back in.
Well, exactly, my Lord. It's the 1971 Act that says you can't come back in while it remains in force, however long that is.
Oh, right, okay.
Relevantly, in one sense, though, in this case, my Lord, I was going to draw attention to that, is that 23.5, Regulation 23.5 is the power that was used to exclude here. But if you go to 23.2, which is the free movement right, 23.2 it is, in an EU context, the equivalent power, which is, I think, at page 40. 23.2 then is the EU equivalent to the point the Lord is making, and I'm going to draw attention to that. It's it makes it clear that you're not then entitled to be admitted as under the EEA regulations if you've been deported or excluded.
So if I go and look at the 1971 Act, I'll find a definition of deportation, and I'll have a description of its consequence, and it's removing from the United Kingdom and not allowed to re-enter during the currency. Exclusion, there's no removal because you're already outside, but there is an exclusion, which means you can't come in again.
Yes, and indeed, one of the reasons why I put it in the supplementary bundle, it was in our skeleton. The Secretary of State's policy says in terms, effectively, we use these two powers. We deport someone when they're in the country. We exclude them when they're out of the country. So they're sort of presented effectively as being two sides of the same coin. From memory, my Lord, I think, and we may be able, I'm sure we can provide it. I think it's Section 3 of the Immigration Act.
I thought it was Section 5, but I can't remember.
Section 5 is the power to deport. I think maybe my Lord's right. I thought
it's early on in the Immigration Act, fundamental which we haven't got in the bundle.
I think Section 3 is the Common Travel Act.
I forget. I mean, I'm just working
from
that.
Five deals with deportation. I think 6 maybe also do.
Yes, sorry, because Section 3 is the Common Travel Area. I think
is that right?
Provision that says you can't.
Sorry, Section 3 of the
Immigration
1971 Act, which isn't in the bundle.
No.
It is. Section 3 of the 1971 Act is in the
Where is it? I didn't
page
realise
9, or are we at cross purposes?
I didn't realise it was in there.
But it's not about the common travel area, or if it is,
No,
it's
well,
lost.
See, I think that's section 1, but
Maybe it is
I'm
section one.
I'm working on my memory. I did look at it again, but
Yeah, no, I can't remember which section it is either. It's quite early on.
Yeah, everyone's been saying section 1, but it's,
I'd be saying section
I think
1.
it won't be section 1.1, but it may be a provision
I
somewhere.
think it's
in
1.3 actually, which
Yeah,
is
no,
why
maybe it is.
my lady is thinking of 3.
Maybe
It's
I've got
subsection
lots in
3.
my brain for that reason.
I think it's 5 is going to be.
Well, anyway, we need to be helped on the common travel area.
Yeah.
Yes, you will.
You might want to add just a definition if you're relying on, if you're trying to say that deportation and exclusion are similar, and just look at the legal consequences of deportation, it has within it exclusion or continued non-entry, precisely because they want to do that. And it's the same. Might be helpful to add into the note the references to the 1971 Act on that.
Absolutely. As I say, though, I would also, just in terms of that, again, rely on 23.2 as well.
Yeah. Yeah.
Well, I think that probably deals with the only other issue I'd vaguely thought about addressing was the intensity of review, but I think given the limited amount my learned friend has said about it, I don't think I probably need to deal with that. It's SC is the authority my learned friend relies upon in the Supreme Court.
Yes, it's quite extensively quoted in the scope of an argument, isn't it?
Both sides, I think, place. I mean, ultimately, just for the court's note, probably the key point I would have drawn attention to is that it makes the point, unsurprisingly, paragraph. It's paragraph 140. It makes the point that, unsurprisingly, Strasbourg continues to apply what might be described as the strict approach to discrimination on the basis of birth outside of marriage. The one exception it noted in relation to that, 142, was the timing, and this is the language of the Supreme Court, the timing of reform addressed to designed to address historical inequality. That's not this case, we would say.
No, thank you
Just
very
turn
much.
around behind me just to make sure.
Thank you, Mr. Sully.
Thank you.
Yes. Anything in reply, Ms. McGahey?
Please vote. First of all, my Lord, in the submission of the Secretary of State, this case does not depend upon evidence about whether in this particular case the Secretary of State could or would deprive Ms. Smith of her British citizenship were she to be a British citizen. In our submission, this is a case about the principle. Is it lawful for the Secretary of State to exclude a person who would, if her parents had been married, not be liable to exclusion? And deprivation in my submission becomes relevant only insofar as it is considered as part of the package, if I can put it that way, of powers that the state has in respect of British citizens, and to the extent to which they are equivalent to those exercised against non-British citizens.
So if he decides against you on that, you lose, even if you would have excluded a dual national. You don't want to argue that.
I'd like to come to the fallback position, my Lord. I don't seek to go over Johnson in any detail again, but I would ask your Lordships and my Lady to turn to paragraph 34 and to the words that Lord Justice Underhill drew to my own friend's attention. No justification has been suggested. And in my submission, those words do create the link between that part of the judgment dealing with clearly unfounded and the second dealing with registration. In my submission, no justification was or could have been suggested because the child of married parents would never have been in Mr. Johnson's position. But Mr. Johnson, as a child of unmarried parents, had no, and of good, not of good character, had no prospect of attaining British citizenship. And for that reason, no arguments of justification were available to the Secretary of State. She could not say, as I can say now, but Parliament has sought to remedy this historic injustice by creating the registration scheme.
I know I drew Mr. Southey's attention to it, but she says no justification has been suggested for it. That means the distinction, which is characterised in the same sentence, being based solely in the absence of birth outside wedlock. That doesn't suggest it has the wider meaning that I was wondering about, or rather it suggests it doesn't have that wider meaning. It's simply saying nobody's tried to suggest that you can justify discrimination on the basis of birth outside wedlock.
Which indeed the Secretary of State doesn't seek to justify
No, right.
in this case
But all that means is that with respect to Lady Hale, if anything, it's surplusage. It doesn't add anything. Whereas you're trying to say, no, it's terribly important. It's all because of the character requirement.
My Lord, if Lady Hale meant simply no justification for the distinction between the married and unmarried, then we'd accept that entirely anyway. But my submission is that looking at the case as a whole and looking at what she goes on to say, the reason that the Secretary of State essentially was bound to lose on that point was that if the good character requirement is imposed, there's really nothing the Secretary of State can say to say we've tried to do anything to remedy this or take a justifiable position. Because once the justification, we don't want to give citizenship to people of bad character, has gone, then there's nothing else left. As far as
why didn't you then not do the first bit and not allow the appeal and simply say the declaration of incompatibility, because that's all that would have been necessary. All that you needed to do is get rid of the bad character requirement, and then it would have been all right. They could have deported. Well, they couldn't then because he wouldn't have the bad character and he'd have the unmarried parents. But why isn't that what she needed to do if that's what she was building up to?
Because, my Lord, the issue that she was asked to resolve was the Secretary of State right to say to Mr. Johnson, your appeal is clearly unfounded?
But she also says in the second sentence of paragraph 35, and it's bound to win. She shouldn't have said that. She should have said it's not bound to win because we're making a declaration of incompatibility and you never know by the time it gets back to you and you have the hearing, which now is no longer prohibited. If a remedial order had been made, he'd have won.
But not on the current state of the law, and I suppose the Supreme Court wasn't in a position to say...
But a remedial order would be adopted. So that's why it's all there. She couldn't be sure that the thing that was the real problem would be removed, and that's why it's there. Okay.
Well, she was asked to address a specific question. Was this appeal clearly unfounded, therefore giving Mr. Johnson only an out-of-country right of appeal?
Yeah. And
at the very least, doubtless the Supreme Court felt a need to say you can stay in the country to maintain your appeal.
She was asked whether the appeal was clearly unfounded on the current state.
Yes.
Yeah.
My Lord, as far as the Secretary of State's point goes that some equivalence has been at the very least attempted by exclusion for non-British nationals and deprivation followed by exclusion for dual nationals. It's not the Secretary of State's case that these provisions are exactly the same. They are extremely similar. So deprivation under Section 40, subsection 2, the 1981 Act, is possible if it's conducive to the public good, and we accept a proportionality test is to be applied. Similarly, Regulation 27, which I apologise is not in the authorities bundle, but we can add it, provides that when the Secretary of State excludes an EEA national, she must comply with the principle of proportionality.
Yeah, well, I think we ought to have Regulation 27, but I know that's correct.
And if anything, the test for exclusion of an EEA national under the 2016 regulations is higher than the conducive test for deprivation because it requires present threat, again under Regulation 27.
So it's the other way around. By definition, if it's proportionate and a present threat, if you get through that, you'd be bound to get through deprivation, you're saying?
Not necessarily, my lord, because that's dealing with exclusion of a foreign national and not with the very serious step to take of depriving a person of British citizenship. But again, as my lord's already observed, there's a great difference between depriving somebody of British citizenship if they've lived in the UK for their entire lives and are now 50, and depriving somebody of British citizenship if they've lived in Ireland and they're now 50.
And you do it 2 days after they've acquired it?
Yes. May I turn to the fallback position, my lord?
I'm just positive. So 23.5, grounds of public policy and proportionality. If the grounds of public policy is adherence to whatever it's called, Al-Qaeda, ISIL, and a threat, a present threat to the United Kingdom, if you meet that, I still think you're saying that you're pretty likely to have met the requirement for Section 40, that the 40 is lower than the 23, but proportionality will take its flavour from the context. But it's difficult to see how proportionality is stronger in the case of somebody who's not been living in England as compared to somebody who's been living in Ireland and coming periodically.
My lord, yes. It is realistically, it is highly likely if the security service assesses that an individual is at danger to national security.
So the language, the first difference, and the proportionality, the third difference, doesn't make a difference. What about the sensitivity, the second issue that was said might lead to a different decision on deprivation of nationality in the case of dual British-Irish national, let's say a dual British-Japanese national, to pick a country at random?
My lord, from the research you've managed to do this afternoon, I think the Secretary of State's submission is going to be it makes no difference.
Makes no difference, okay.
There will be a fact sensitivity.
But not illegal. If it's a threat, and that's the end of it, you say?
Yes.
No.
And the extent of a person's ties to the UK.
That's proportionality.
Yes. And may be more relevant in the case of an Irish national where there is a historic closer link.
Yeah.
But as a matter of law, I am fairly certain that the Secretary of State submissions will be that the EEA regulations apply to an Irish national.
No, I understand that. That's not the question at all. That's anything but the question. The question is the second submission that is made, that even if the regulations apply, would she, although she has the power, not exercise them because of greater political sensitivity of taking away an Irish national's British citizenship as compared with a Japanese or a Taiwanese or any other national? And that's a specific question.
It is
just to spell it out and make sure that I'm thinking what my lord is thinking, because of the historically very close ties between Great Britain and Ireland, or perhaps I say the UK and Ireland, sharing partly the same island, sharing 900 years of history and sharing a common travel area.
And with political consequences
and
if things are done.
Possibly with political consequences in the light of the Good Friday Agreement and recent history generally.
My lord, so far we've come across a piece of guidance which recognises the sensitivity and says that the Home Office will take action. I think it's in the context of deportation, but it's dealing with the whole lot. only when it is in the public interest, which doesn't really take us very much further.
No, well, thank you. Obviously, we can't ask you to say more than that at the moment. Sorry, where were you going to? You were going to go to for your fallback position.
My Lord, yes. Clearly, the Secretary of State's primary position is that discrimination lies in the fact that Mrs. Smith is not a British citizen when a comparator born to British parents, married parents, would be. And that is a present and continuing difference of treatment with real consequences. For example, she can't have a British passport, she can't seek British consular assistance. And so there is a present, ongoing inability to take advantage of the rights of British citizenship. If we are wrong about that, and discrimination has to be considered essentially at the time of the last act, if I can put it that way, the decision to exclude. And if it is the court's finding that discrimination occurs at that point, then the next question must be whether that discrimination is justified. In that situation, the comparator would be, in my submission, the British-Irish dual national, about whom there were national security concerns, which is a suggestion made by the court on Sunday.
And do we know what you would do? Or do we have to send it back and have evidence?
My Lord, my submission is this is a matter of principle. It's not a matter of evidence.
How is it a matter of principle? Because we don't know whether you take it away or not.
We don't, my Lord.
For
the purpose, sorry, I didn't mean to interrupt.
No. So if we don't know whether you take it away or not, we don't know whether the end result will be the same for the dual British-Irish national as it would be for Mrs. Smith.
My Lord, for the purposes of this comparison at this stage, my submission would be that the comparator, one should assume with the comparator, that the comparator has not been deprived of British citizenship, certainly at this first stage.
Right.
Because even at that stage, my Lord, assuming whatever reason, no deprivation decision is made, so this person, this theoretical comparator, remains someone who's perfectly entitled to stay in the UK.
Yeah.
In my submission, exclusion would still be justified.
Yeah.
And that is because the Secretary of State is entitled to take measures that address a present threat to public security.
But is she entitled to do so on a discriminatory basis?
It happens all the time, my Lord, because the Secretary of State has the powers of exclusion and deportation in respect of a foreign national that she does not have in respect of a British national. The powers are simply exercised differently.
That sounds like Belmarsh all those years ago. You can protect the state, but you can't protect the state from some groups and not others. And if the reason why you're protecting her from Smith is because her parents weren't married, but you weren't protecting them from Jones, whose parents were married.
One would have to take different measures. So they were, for example, one could prosecute, assuming Miss Smith is excluded and she's not in the country, prosecution's not an option. One can impose a TPIM.
So all that would happen is she'd have to register, and you've got this guidance, and you tread very softly, but we don't know how softly, and that's what happens.
Assuming she's not deprived, and that will put her in exactly the same position as a dual British-Irish national whose parents were married and who wasn't deprived either. And so, my lord, my submission is even in that situation, the distinction would be justified, because the Secretary of State is entitled to take what measures she can in respect of the protection of the United Kingdom from foreign national terrorists.
And then just so I'm absolutely clear in your own mind, there isn't a new fallback position, and if we don't accept that, you still don't want it remitted to argue about whether or not the likelihood is that you would exclude, deprive and exclude British dual national. You don't want us to go down that route at all. It's all or nothing.
If the court feels that the only way in which this issue can be decided is on the evidence as to whether the Secretary of State would deprive, then, my lord, yes, we would ask for that. Because
that's it's not what we want, it's your third position. If you win your primary case, you're delighted. If you win your alternative case, you're reasonably happy. And the next question is, if that hasn't happened, whether you want anything else or not.
On the second...
And it's not what we would like to give you. You're placing the order in the restaurant.
Well, I certainly understood you to be saying that although if you told the other two were off the menu, you would ask us to remit.
Yes.
You would then.
It is the Secretary of State's position that this appeal can be resolved on a matter of principle rather than evidence.
But if not, if it depends on evidence, then you'd like us to remit, so you'd have the opportunity to put in evidence, should you so choose.
Yes, because although my submission was that if the comparator was someone who had not been deprived,
and it might, in fact, if you got evidence, show that the comparator wouldn't have been somebody, on the facts of this case, who would not have been deprived.
Or indeed would be, because opposition would, essentially, there would be then even
less
of a difference.
You might have 6 similar cases and say, look, she was a group of 7, the other 6 weren't Irish and they've gone, and she's Irish and I know it's sensitive, but she's going as well. You might have that sort of evidence, to create facts, So you would like to remit and have the opportunity to put in evidence if you think it appropriate to do so.
Please, my lord. Because if the Secretary of State is right, and that if the comparator is somebody who's British-Irish and is not going to be deprived, but just subject to different anti-terrorism measures, and if that is right, then the Secretary of State must be even more right, if I can put it like that, if deprivation is available to the comparator. Because if the comparator is going to be deprived and excluded, that puts that comparator in a very similar position to Ms. Smith, who is being simply excluded. And therefore, the justification in treatment becomes even more solid, if I can put it in that way.
The only problem is I don't have any fear for the moment as to what anti-terrorism measures would be applied to a dual British national whose citizenship wasn't deprived, and how that compares to exclusion. I just don't know.
It's immensely fact-specific, my
Yes.
lord. Because assuming there's no prosecution, the most common method of addressing terrorism is the use of a TPIM order, and that is tailored to the risk posed by the individual.
Are there any other, just so that we can be clear what the potentially available measures are, is it realistically prosecution or a TPIM, or is there anything else that we should be aware of? Just so we know what we're thinking about.
Of all the measures enforceable by law, yes, they are the only two.
Those are the only two?
Yes.
All right, that's helpful. Thank you.
So she wouldn't have to be deprived. She'd be get citizenship. You go to Dundalk, do the citizenship ceremony, pay the £80, get British nationality as well as the Irish nationality, and then she'd be able to hop on the ferry in Dublin, come over to Britain, and then you'd slap a TPIM on her.
A TPIM.
Because that's how you'd have to deal with her then, you see.
Or deprive, my lord. Because a TPIM would be extremely difficult for somebody who just wanted to come across the
saying,
border.
At the moment, I find this particular fact scenario very odd. If they have got dual nationality, why wouldn't you deal with it by way of deprivation? Or deprival? I don't know what the right word is in this context.
I tend to use deprivation, my lord, but I don't know whether that's
Doesn't
right.
matter. The substance.
My lord, the only reason I put the hypothesis that one imagined no deprivation was essentially to put the worst case in terms of justification, because in my submission, even on the worst case, the Secretary of State is justified in excluding on grounds of national security. Because if she faces a foreign national who poses a threat, and the only realistic way of dealing with that threat is to say, you cannot come into the UK, then she's entitled to do it, even if her comparator is somebody who would not suffer that outcome.
Well, in what circumstances will that be the case? I mean, the comparator is by definition also a dual national.
Is it a comparator is a dual national who also poses a risk to national security?
Yes, right. So why wouldn't? I see there's a subtle argument about the different approaches to deprivation and exclusion, but I can't see any situation in which it's realistic to say that the comparator wouldn't have been deprived, but would have been subject to these other measures.
It seems unlikely, my lord. I mean, my learned friend says, well, deprivation is a draconian measure. It's got to be taken essentially with even greater scrutiny. And my submission is it in almost all circumstances it would be the same, particularly if the British-Irish dual national is someone living outside.
Quite.
If living in
Ireland.
Living in Ireland. A lot of the anxiety about the draconian nature of the Act.
Well, that's why your first alternative, the assume not deprived of British nationality, that's the thing I find odd, because when you explore it, if that person if you assume you don't deprive that person of British nationality, then you've got exactly the same problems with the Irish national, not a dual national, born out of wedlock. It's exactly the same situation. And I can't understand why you're taking steps in relation to one and not steps in relation to the other when they both are Irish nationals and they both present the same risk. Can you see my difficulty?
I do, my lord. I started with the higher point simply to submit that even if there was a great disparity in the way you dealt with comparators, it would still be justified because national security
is so important. Yeah.
But as a matter of fact, I do accept that in almost all cases that one can imagine, if Ms. Smith had a next-door neighbour whose situation was exactly the same as hers.
She had a sister, and by the time the sister, it wouldn't matter because if the parents even married.
Stick with the next-door neighbour.
The next-door neighbour. The children were born on exactly the same day, but the parents next door were married.
Yeah.
And they posed exactly the same risk. They were both supporters of ISIL, and the threat they posed was sufficient to justify exclusion. In my submission, it's almost inevitable that the next-door neighbour would be deprived of her citizenship and then excluded.
Right.
Yes.
Anything else?
My lord, no.
No. Well.
May I just ask?
Yes, of course. So sorry. Yes.
Just to cover one point that Mr. Sully raised in his submissions. Are we to take it that you accept, as it were, sub silentio, that the test for justification in this context is very weighty reasons, or are you maintaining the position taken in the skeleton argument?
Maintain the position in the skeleton argument. We do accept, of course, that marital status is one of the suspect reasons.
Yeah. The skeleton argument, by reference to several paragraphs in the recent decision, finesses that effectively.
It does.
I'm slightly oversimplifying. Yeah, okay.
Well,
I think.
Well, the only thing, I'm conscious of time, the only thing that I think I may have a right to respond to is that the learned friend for the first time has suggested a permission for fresh evidence. I suspect it's probably obvious, but our point in relation to that is simply too late. But,
well, I strongly suspect if we get to that point, I think we would hear further argument on what the correct, on the whether it was appropriate to remit for fresh evidence. Certainly, speaking for myself, I commit my lord and my lady in circumstances where they wouldn't need it, but I think we'd have to have got through so much argument that I think it'd be imprudent for us now to decide that without giving you both an opportunity to say something about it.
Well, I can see one scenario. I mean, there are so many possible ones, but I can see a scenario where I go home and I think, gosh, wrong exam question, set the new paper, send it back and let them all sit it again.
I think the sensible course is that we won't commit ourselves definitively to entertaining further submissions if that situation arises, but we will, it's noted that you take the position that it's too late.
yes.
That's really all that needs to be said, isn't it?
Yeah.
Yeah. Yes, thank you. Thank you very much for your submissions in this not straightforward case. We will, of course, be reserving our decision. Copies of our judgments will be circulated in draft so that the parties can agree the terms of a consequential order, and if they can't, prepare brief written submissions so that we can decide between those submissions at the time of and produce a final order at the time of hand down. Also, of course, to draw attention to any typographical or other minor factual errors. I don't think I need to remind you of the very limited purposes for which a draft judgment will be circulated, which affects who it may be further circulated to. It's all in the Advocate General for Wales case, or Counsel General for Wales case. So sorry.
My lord, on that, can I raise, because there was obviously already an argument about jurisdiction in relation to that. Because
in relation to what?
In relation, in relation to the circulation, we wasn't argument. Sorry, in relation to the argument about jurisdiction, we ended up taking the view that we had to apply to enable this judgment to be signed, shared with the solicitor at Phoenix Law, who are the Northern Irish solicitors instructed in the matter. That was granted, but to avoid any delay,
I can't see any difficulty. It's not you can't circulate it. It's that you can only circulate it to people who have a real need to help you with the purposes of circulation, not therefore to take the Counsel General for Wales case to people in your chambers to prepare a press release about how wonderful you were to win the case, whichever of you it turns out to be. Yes, but that would be simply because that they are involved in the case and would be necessary to give you instructions.
Exactly, my lord. So we did get approval, but we were just very cautious, and given the sensitivity of the case, to get approval for that.
They are subject to normal professional obligations in Northern Ireland. It would be contempt, and it would be terrible for their careers.
Yes,
and so on. So they're not going to be able to do it with impunity, even if we suspected that, which I say immediately we don't.
Yeah. Yes.
Yeah. The answer is that when it is circulated, provided it is for a proper purpose, there would be no objection to it being circulated to the solicitors in Northern Ireland. Right.
Thank you, my lord.
Thank you.